All right, good afternoon, everybody. I'm pleased to be here with our Attorney General, Irv Nathan, for today's announcement. I think you know, as I repeatedly said, that I'm committed, my administration is committed to playing a leadership role in moving forward campaign finance reform in the District of Columbia, in concert, of course, with the Council of the District of Columbia. During the spring, I asked Attorney General Nathan to conduct a thorough examination of the law and practices nationwide and to propose ways of updating our laws to reflect ways of ensuring transparency and integrity in the political process. In late June, the Attorney General outlined to the Council in a hearing, I guess it was almost July, the end of June, the Attorney General outlined to the Council the principles we would follow in drafting our proposal. Today, we're pleased to present the results of those deliberations. Before I turn the podium over to Attorney General Nathan, I want to mention that this is another step that my administration is making the effort to address in terms of strengthening government accountability. That's a strategy that is included in our One City Action Plan. For those who would like to go and review that, you will see mention of that particular area, and this builds upon that. As the action plan cites, I'm committed to an accountable, results-oriented, responsible, and ethical government. For example, we formed, after the Council adopted the legislation, the Board of Ethics and Government Accountability, and implemented employee ethics training as well as a pledge. I think many of you will recall, of course, that former Attorney General Spagnoletti is chairing the Board of Ethics and Government Accountability, and two outstanding citizens are working with him on that board. We want to assure, of course, that the tax dollars of the residents in the District of Columbia are spent wisely on a government that works, and every public servant remembers for whom they work. That's one of the reasons, for example, we launched grade.dc.gov to give residents more input in assessing the services provided in the city. As Attorney General Nathan will explain, we are posting the campaign finance reform proposal online and making it widely available so that we can review comments before formally submitting the legislation to the Council when it reconvenes. I think it's on the 17th of September, so there's several weeks before they even come back. I'm now going to ask Attorney General Nathan if he would come up and discuss the details of the proposed bill and address any questions that may arise. Are you going to talk about the public citizens? Okay, good. Okay, great.
Good afternoon. Thank you, Mr. Mayor. I'm delighted to be here today. As the Mayor explained, our office was requested in the spring to propose a bold, comprehensive, and systematic set of changes to our campaign finance laws. The goal is to ensure that going forward, our citizens would have full confidence in our elected officials and the fair functioning of the government. After researching the laws and practices in other comparable jurisdictions, and working with my career colleagues in the Attorney General's office, we fashioned this legislation. We fashioned the outlines, and then since the time of my testimony in late June, we've put it into legislative form, and as you know, the Mayor proposes to submit it to the Council when it returns from recess. The principal goal of the bill is to seek to combat even the appearance of corruption or favoritism, to ensure robust protection of First Amendment rights to our citizens, and to provide for prompt electronic disclosure of contributions and expenditures so that the electorate is fully informed before it votes. What I'd like to do this afternoon is to detail briefly the essential features of the legislation and then take questions about how the legislation would function if it is passed. The first and most significant part of the legislation are the very stringent pay-to-play prohibitions. Under the bill, no one holding or seeking a government contract or grant in excess of $250,000 can make any contribution to any candidate or office holder who would have any opportunity to weigh in on the contracting decision. This ban would extend not only to the candidate but to any organization that the candidate or official controls or any constituent service program under the control of the candidate or the office holder. The ban would extend to officers and directors and related parties of the government contractor. The ban would extend from the time the solicitation for the contract is extended until 1 year after the payment on the contract or the grant. We would make an exception for relatives of the controlling officer, but only up to the amount of $300 for a candidate. There are tough penalties for violations on both the donor and the recipient, and the district in its discretion can terminate the contract or grant if there's a knowing violation. Second, the bill would prohibit bundling by registered lobbyists. Lobbyists would be able to make their own contributions up to the statutory maximum, but they cannot solicit or transmit contributions of others. Bundling by others than registered lobbyists would be permitted, but if that bundling exceeded $15,000, that bundling would have to be disclosed. Individuals would not be allowed to evade statutory maximums by contributing through a number of corporations that they control. Essentially, corporate contributors would have to list their controlling shareholder and all affiliates and subsidiaries. Any corporate contribution would be attributed to the individual, and no individual would be allowed to go beyond the statutory maximum. So if, for example, a corporation controlled by an individual were to contribute $1,000 to a mayoral campaign, that individual would not be allowed to contribute more than another $1,000, since the maximum is $2,000. The bill will require disclosure of all contributions to and expenditures by independent political action committees. It will also require representatives of those committees to certify that they have not and are not coordinating with a candidate or the candidate's committees. As you know, under the Supreme Court decision in Citizens United, there cannot be caps on the contributions to these kinds of independent committees, but disclosure can be required, and this bill requires complete disclosure so that citizens know where the money is coming from and where it is going. Under the bill, disclosure must be made electronically unless a candidate can make a showing of actual hardship. Contributions in the last 30 days of an election would have to be made on a daily basis electronically, and the Office of Campaign Finance would have to disclose the filings within another 24-hour period. The bill puts additional requirements on candidates in filings to the Office of Campaign Finance. A candidate cannot claim willful blindness. A candidate will have to certify that the filing is true to the best of his knowledge, information, and belief, and in addition, that that person has taken reasonable steps to ensure that the filing is accurate, that the campaign is in compliance with campaign finance laws, and that contributors have been informed of their obligations under the law. Money orders will be allowed, but will be limited, like cash contributions, to a maximum of $25 per person. The bill will also provide for enhanced penalties for violations. There are civil penalties that can be as much as $10,000 for each offense. Contribution penalties can be as high as 3 times the amount of the contribution. And as I mentioned, in the case of government contractor or grantees, they can lose their contract or grant. And the criminal penalties will also be enhanced. They can provide for a maximum up to 5 years imprisonment for each violation. The U.S. Attorney would continue to have exclusive jurisdiction with respect to felony convictions or violations, but our office, which, as you know, will be an independent elected office after 2015, would have concurrent jurisdiction with respect to misdemeanor prosecutions. I think that under this legislation, and we've discussed this with the mayor, that the resources of the Office of Campaign Finance are going to have to be increased in the future. They're going to have additional funds for investigators, for auditors, and for enhanced software programs to be able to ferret out violations. In addition, they will be allowed to, as they can now, issue advisory opinions as to what would comply with the law or what would violate the law. And there is in the legislation a safe harbor provision so that if an individual who is governed by this makes a request, provides accurate information to the Office of Campaign Finance, and then follows the advice that they get from the Office of Campaign Finance, they would have a safe harbor from prosecution. As the mayor mentioned, this proposed legislation will be on our website at the Office of Attorney General starting today. We welcome comments or suggestions for improvements. We'll continue to work on it up to the time that the legislature reconvenes, and with any changes, we'll submit it to the mayor, who will have it transmitted to the council for introduction by the chair. Obviously, we can also work on improvements thereafter, and I've promised Chairman Bowser that we would work with her. Let me say that with respect to the other bills that are pending before that committee, in our view, this bill is a comprehensive legislation that covers all the bases. There wouldn't be any need to enact the other provisions. With respect to those bills, some of them, in our view, have some constitutional potential problems, other defects, other things that maybe aren't as wise, and then other things that are in there that we think make sense have been subsumed within this legislation. So this would be comprehensive legislation that we'd hope the council would pass. Finally, I want to thank my colleagues in the Office of the Attorney General who worked so hard on this legislation, and now prepared to answer questions about the bill. Yes, Bruce.
Continue a conversation we were having earlier. Could you sum it up for us? How does this legislation change the status quo in terms of how elections, campaign contributions have been made in the district?
Well, the principal ways are, first of all, the pay-to-play prohibitions come into effect. We haven't had any. We looked at the jurisdictions like New York, Philadelphia, and New Jersey that have pay-to-play and that have worked. And so, in the first place, people would be confident that decisions with respect to contract made by the Office of Contracting Procurement and ultimately by elected officials would be uninfluenced by any contributions, and I think that is a significant change. Also, bundling would be, by registered lobbyists, would be prohibited. As you know, it's now the practice. A lot of lobbyists, they bundle other people's contributions, and it is perceived, if even it's not the case, that they get extra access to the elected officials for whom they bundled and made those contributions. So that would be eliminated. The disclosures would all be electronic and would be prompt, and those contributions that come in within the last 30 days, which are a number of them, they would all be made very promptly, so there'd be no delays, and people would know in advance exactly who's contributing. So I think those are the main things. And but in addition, with additional resources to enforce these laws, and with the addition of the Office of Attorney General, which under current law does not have a role with respect to enforcement of campaign finance, and I think it's always better to have, two sheriffs on duty. And the U.S. Attorney would continue to have exclusive jurisdiction with respect to felony prosecutions, but our office, or the Office of the Attorney General, which I mentioned, will be elected and completely independent starting in 2015, would have the ability to bring misdemeanor prosecutions. Yes, so.
How would your office and the U.S. Attorney's Office decide, to prosecute what?
Well, under the legislation, if we were to investigate, or our office were to investigate, we would notify the U.S. Attorney of our action. Obviously, we'd be focused on the misdemeanors, and if we thought it advanced to the level of felonies, we would transfer the matter over to the U.S. Attorney and suggest that they handle it, whether they would or not. That's their independent decision. The legislation contemplates that there be a coordination and that they would know what we're doing, but we would have a role which we do not have currently. Yes?
Can you explain again the timeline for the restrictions on those seeking or holding contracts donated?
What we try to do is to make sure that we're dealing with appearance issues here, and so that as soon as it is solicited or that the potential contributor is aware that there is going to be a solicitation of a contract in the magnitude we're talking about, which is $250,000, that from that point on, the potential government contractor or grantee would not be permitted to make a contribution, and that would last for a year after the conclusion of the contract or the conclusion of the last payment under the contract. And the legislation also requires that there be a certification by the bidders on the contract that they have not made a contribution in that period of time, so that there would also be potential false statements if contributions had been made in that time by the potential bidder. Yes, Ms. Brazil. Sorry? Sure. Okay, Mark.
It seems, we were talking before, that there is a window prior to the solicitation being issued that a contractor could make donations in advance.
Well, a company that is ultimately going to get a contract, they wouldn't be a contractor at the time of the contribution, but that is right. And so, you know, if you did it before you knew that there was going to be a solicitation for the contract, that would not be held against you. You'd still be allowed to contribute. Ms. Brazil?
I've had two questions. My first question is, can you walk us through the process you used and who you consulted with in terms of drafting this?
Yeah. We first of all assigned it to our career lawyers in the legal counsel division to do research as to what other jurisdictions were doing. In addition, we consulted with interested individuals in this community, people who had previously held elective positions in the council, people who have been involved in good government organizations, both locally and nationally, which leads me to mention, as the mayor asked me to do, as you see from the handout, Public Citizen has issued a press release today which says that our pay-to-play prohibitions are some of the strongest in the nation. Full disclosure requires me to tell you that Public Citizen was one of the organizations that we consulted. They spent a lot of time looking at campaign finance laws around the country. They had created, before we went there, a matrix of what other jurisdictions have done, and we took a look at that to make our own decisions. And they even provided some drafting assistance to us on the pay-to-play prohibitions based on specifications and requirements that we established that we thought were appropriate for the district. So that's the nature of the, and we dealt with other national organizations that deal with this and other citizens in the district. And we fashioned then, based on that, recommendations to the mayor. The mayor endorsed those recommendations, and once he did, then I testified in the council as to what the principles were, and following that, we put this in a legislative form.
I guess my question goes to, a lot of the principles you're seeking to achieve are principles that everyone could adhere to, or national principles. My question is, did you have conversations with people who are familiar with the ways and the troublesome nature of past campaigns in the District of Columbia?
Yes. I think I answered that. We talked with people who were elected officials. We talked to people who were campaign managers in prior campaigns. I think we talked to people who are involved in political activities in the district in a non-elective manner. So we tried to get the broadest consensus of what were the problems, what were the issues, and what were the solutions that they saw. And as I say, we also looked at what other jurisdictions have done. Yes, Patrick.
Follow on Dorothy's point, given all the different incidents we've had over the years in campaign finance issues, how confident are you in the current Office of Campaign Finance to implement these new regulations?
Well, I believe that they need some additional help there, to be candid. I think their hearts are in the right place, but I think that they may be outmanned by the lack of resources. I think they need additional investigators. I think that they need encouragement from the council which, if they pass this legislation, would provide some encouragement to be more vigorous and to utilize the other resources like our office and the Attorney's Office to enforce the laws.
But clearly you see a need for your office to play some sort of oversight role in this that wasn't.
Well, not oversight role, but assistance in the enforcement side. And of course, we could also be involved in opinions and in trying to help people to understand the legislation and to abide by it.
You don't see any need for a change at that office for this to be implemented, correct?
No, I don't think so. You know, now we have a couple of situations. First of all, we have the Board of Ethics, which is gearing up and will focus on ethical matters. So now the Office of Campaign Finance and the Board of Elections can focus exclusively on campaign finance matters. So that reduces their burden and trains their focus on this matter. With additional resources and with help from other agencies like ours, I think they can do a good job. Yes.
You mentioned a lot today about avoiding appearances.
Right.
So I have to ask, what about the appearance of this legislation coming from an administration in which mayors under federal investigation, a woman has pleaded guilty to helping the city's biggest contractors funnel $650,000 to a shadow campaign and $43,000 of straw donations to the legitimate campaign. Feels like the elephant in the room here.
Well, look, I think that is a background here that we can't blink. Our efforts were started and made before any of that emerged, but obviously the fact that that's out there gives increased urgency to the situation. But I think the main point is it's a question of what are the merits of this proposal. Will this proposal, as enacted, help to improve the confidence of the citizens in our electoral process? And so I think you need to focus on the merits of the proposal, and I think you have to commend the mayor for urging that we do this and encouraging us to put something together as comprehensive as this is and to be enacted. And we'll certainly urge the council to enact it because we think it's the right thing for our city.
I think the proposal will have to stand on its merits. That obviously will be evaluated by many people.
Mr. Mayor, can we get you at the mic?
Sir, can you go to the microphone, please?
I support what the Attorney General said. I think the proposal will have to stand on its merits. It will be evaluated by many people, obviously the members of the council. Citizens will have a full opportunity to weigh in on this, and I hope people, assuming there will be a hearing on this, I hope people will weigh in. So there will be lots of eyes, lots of brains that will focus on this, and where it can be improved upon, we certainly invite that, but it frankly, hopefully advances the effort to address some of these issues that have been raised before. Again, Public Citizen is obviously an organization that is highly respected by many. We appreciate the fact that they assisted the Attorney General's office in crafting this piece. We hope they will continue to weigh in as well. So by the time this journey is done, there will be dozens and dozens of people who will have had the opportunity to weigh in.
Yes.
Did you consider the proposal, which may or may not be on the ballot this year, to ban all local contributions? Why did you decide against that? Do you think that proposal was constitutional, based on what you know about Citizens United? I believe you did rule that it was constitutional.
Yes.
Why not?
As the law currently stands. I think we did obviously consider that initiative, which has not been approved by the Board of Elections, but is in the courts now for whether it has adequate signatures. In our judgment, that was too much of a blunderbuss to say that all corporations could not contribute. First of all, it has some constitutional problems if it relates to independent expenditures. But as I said in my opinion to the Board of Elections, as matters currently stand, with respect to corporate contributions to campaigns, the Supreme Court has not struck that down. It has been held constitutional, but the writing's on the wall in terms of what the Supreme Court is saying about First Amendment rights of corporation. So we looked behind the proposal to see what's the reason for the proposal, what are the concerns about corporate contributions, and we found that the concerns are, first of all, that these corporations may be getting government contracts, so we dealt with that issue. We also dealt with the issue that some straw corporations or even legitimate corporations are being used to evade the maximum limits, and so that there is shenanigans with respect to the number of corporate contributions, so we eliminated that. So we worked on what was really at the heart of the matter and did it in a way that I think will avoid a constitutional challenge. I think the courts have made it clear that where your focus is on avoiding even the appearance of corruption, and that happens in pay-to-play cases, that this legislation is upheld. We obviously, in drafting this, we're keeping an eye on the possible judicial challenge in the future. And I think that the initiative is going to, it's already in court, but I think if it were ever to pass, it would have some challenge, and we're trying to avoid that. Okay? Yes?
Just off the top of my head, I think about 7 council members are going to be on the ballot in November, and you're asking them to mull this proposal while they might be actively raising money, spending money. Do you think that complicates matters?
Well, I don't expect that this legislation would be in effect for the time of the next election. I would think that...
Just the idea that they're engaged in the practice while they're mulling over changes to the practice.
Well, I think that's all the better time to do it. They know what's going on. I think they can see what the problems are and what the... so I'd hope that they could do it and make it effective, let's say, the beginning of next year.
Well, we have questions for the mayor as well. These are technical questions. We could ask some. Well, now you're telling us one question. I would prefer to say my one question for the mayor.
Okay, I'm glad to hear that, Mark. Good. Bruce?
Well, no, I agree with him. I mean, he
Okay.
said one more question. Can we get a question into the mayor?
Absolutely.
2 more questions.
But I have one more question.
I'll stand by him, but
Question
you can ask the
for
mayor.
Attorney General. Wait, are you taking one more question?
I'll take one question.
Okay. Did you consult with lobby shops, law firms?
We did talk to people who are registered lobbyists and people who are at law firms, and we talked with the American Bar Association as an example on that issue as well. And you know, let me say that one point I didn't make is that with respect to, you know, we try to reach a balance here. We want people to be able to raise funds and campaign and get their messages out effectively. We're not trying to interfere with that happening. And we didn't propose any changes in the statutory maximums, which is, you know, is $2,000 for the mayor and $1,500 for the council chair. But obviously, if the council believes that our proposals are sound but might affect their ability to raise funds, one kind of approach is they might think about changing the maximums and raise that somewhat. So we certainly aren't trying to interfere with people to get their message out, but we want to do it in a way that gives confidence to the population that everything is fair and on an even playing field.
Mr. Mayor, can we follow up? Mr. Nathan already talked about the pressure, you know, given the climate, given the scrutiny that your own campaign is undergoing. I mean, how do you feel about this legislation? How do you feel about coming out with this legislation now? What are your thoughts?
Well, I feel perfectly comfortable coming out with it, Bruce. And this is not the beginning of this discussion. This goes back to several months ago when I asked the Attorney General to look at this issue. We said we would have some thoughts on this by mid-May, and just within that same time frame we did. We were invited by the council to come and testify. We cooperated fully in that instance and laid out the principles that then were used to undergird the development of this legislation. I think we promised that by August we would have a proposal when Attorney General Nathan testified before the council. So this is yet another step in a set of commitments that we made several months ago. So we're simply following through, Bruce, with those commitments.
But do you think this legislation goes far enough? Do you think it goes too far? I mean,
No,
it was-
I support it fully, because this is something that we've worked, the Attorney General has worked with us and others on, but it now is obviously in a draft form. Oftentimes, legislation that is proposed by the mayor is simply transmitted, and then it becomes a subject of reaction by the public or the council in a hearing. There's an opportunity now for the public and others to be able to react to this in draft form, because it won't be transmitted at the earliest until September 17th. So we're trying to make this, you know, as transparent and open as we possibly can, Bruce, and we will certainly consider to weigh additional suggestions and recommendations that come in even before it's transmitted to the council. And like any piece of legislation, once the council gets it, it's certainly subject to amendment and change. But I think, again, this has been a multi-month effort on our part, and this is simply the next step in that process.
I have one related question.
No, Mark, and then one more.
What do you say to people who, to citizens who hear the U.S. Attorney say that your 2010 campaign deceived the voting public, that there was a shadow campaign that helped you get elected, and that you're not the right person to be bringing this kind of legislation forward in light of the federal investigation and what the U.S. Attorney has said about you?
I would say what I said before, Mark, and I think the proposals that are being advanced will have to be evaluated on their merits. I don't think there's a matter. I don't think the most useful thing is to evaluate me or anyone else in the course of this. I think you look at the proposal and you think whether you determine whether it has merits. If people think it has merit, then I would hope they would support it. If they don't, I think they would. I hope they would have a different idea. No, I mean we've obviously testified before the council, but we put forward the principles. Many of you were, you know, in one way or the other at that hearing. So you saw the reaction of the council there, but this will be the next step in that process. This is an iterative process, and you know, we'll see what the reaction is to this proposal.
Mr. Mayor, an unrelated question. Washington Business Journal today.
Tim, we're doing other questions. Alan Blinder has the last question on this, and then we're done.
Well, I hate to ask a question.
No,
Alan.
Following up on Mark's question, you obviously you send a lot of proposals for the council. How much political capital are you willing to expend to push this through? How high? Where does this fall on your list of priorities?
It's very high. I think it's one of the most important issues that we face in the city at this stage. Again, we put a lot of effort into it. You see, we have the Attorney General. We have many members of our Office of the Attorney General's, the Office of the Attorney General who've been involved in this. So we've invested a lot already in putting forth this proposal. And I'm going to do everything I can to see that it's adopted. We'll work closely with the council, as we do on many things, to try to, you know, eventually have a product that we all can support. But it's at the highest level, Alan.
Thank you guys very much. Tim, what's your question?